give some contours of how we are going to do this. My Lord, all three of us, the petitioner will submit at various points of the day. My colleague here, Mr. Chibiga Ismail, will start. They are contained in 4 volumes, these files. My Lord, they are paginated. I was saying, my Lord, that they are paginated. They run from pages 1 to page 1746. And my Lord, in the course of submissions, each one of us shall be referring you to a specific page of the bundle where the particular holding that we shall be referring to appears, my Lord. And with that, my Lord, I think that we can now start, and we'll start, as I've said, with Mr. Chibiga Ismail. I'm obliged, my Lord.
For the record, my Lord, my name is Chibiga Ismail, and I'm going to take you, my Lord, through the first part. My Lord, I'll take you through the brief facts first. The facts of this petition are non-disputed. My Lord, the petitioner and the first respondent participated in the recently concluded general election, by-election, Kawempe North constituency, as candidates. My Lord, the second respondent returned the first respondent as the winner and was gazetted on the 24th day of March 2025. My Lord, the petitioner was aggrieved by this declaration and hence brought this petition, chiefly on two grounds. Ground number one, that the election was conducted in non-compliance with the provisions of the law, and that non-compliance, my Lord, affected the results in a substantial manner. Secondly, that the first respondent and his agents, with his knowledge and approval, committed illegal practices on the election day and before the election day. My Lord, during trial, 4 issues were agreed upon to be disposed of by this honorable court. The first issue, my Lord, was torn a little bit down on the last day of cross-examination when the first respondent applied to expunge a few affidavits. So, my Lord, then the issue reads whether the affidavit of Ben Mukasantale, they were 3, but 2 of them were expunged. Whether the affidavit of Ben Mukasantale in support of the first respondent's answer to the petition is legally admissible. Issue number 2 for the court's determination is whether there was non-compliance by the second respondent with the provisions of the Parliamentary Elections Act relating to elections, and if so, whether the non-compliance affected the results in the substantial manner. Issue number 3, whether there was an illegal practice or any other offenses under the Parliamentary Elections Act committed by the first respondent in connection with the election, personally or with knowledge and consent or approval. Then lastly, my Lord, what are the remedies available to the parties? My Lord, during the course of the hearing, we indicated to you, my Lord, that we shall raise preliminary points of law. The court guided your Lordship that we shall raise them at this stage of final submission.
I have an issue with the way he read out issue number 2. I don't think we agree that the way he amended it, how it was captured in. The issue was whether it was done compared to the provision of the Parliamentary Elections Act, not with the second respondent. And if so, when it affected the users in a substantial manner. So I think it was not specified that had framed the issue of non-compliance with regard to the second respondent. It was a provision of the Parliamentary Elections Act. So if he addresses it the way, or if court captures it that way, would affect the way we had prepared our submission.
What they have was whether there was non-compliance with the provisions of the Parliamentary Elections Act, and if so, whether the non-compliance affected the results of election.
Yeah, I love that. Yes, it does, my Lord. Yes.
I am obliged, my Lord. My Lord, we indicated, I was saying that we indicated that we shall raise preliminary points of law, and the court guided that we shall raise them at this point of the final submissions. My Lord, the first preliminary point of law is that affidavits is in respect of affidavits that predate the answer to the petition. It is in respect of affidavits that predate the answer to the petition. My Lord, the record of the court reflects that the answer to the petition was prepared, sworn on the 23rd day of April 2025. It also reflects that the affidavits of David Lewis Rubongoya, the record also reflects that the affidavit of David Lewis Rubongoya, Ben Mukasantare, Sylvia Nachobe, Damba Kezekia, and Chibirige Musa was sworn on the 22nd day of April 2025. Now, my Lord, the problem with these affidavits is that they support an answer that had not been existent. They are sworn a day before the answer is in existence. And my Lord, Rule 81 of the Parliamentary Elections rules permitted the first respondent to file his answer once he was served with the petition. Rule 81, 8. Rule 8, sub-rule 1, permitted the first respondent to file 8, sub-rule 1. Yes, 8.1. Yes, 8.1, my Lord. Permitted the first respondent to file his answer, and that answer would constitute a pleading. And his answer would constitute a pleading. My lord, in Kayanja vs. DePaul, this authority is on page 22, volume 1 of our authorities. Is on page 22. It was held, my lord, that the answer, yes, it is the highlight. It starts at page 1, my lord. Yes. It says, my lord, that the answer to the petition is like a pleading, akin of a written statement of defense. The answer to the petition is a pleading akin of a written statement of defense. My lord, in an ordinary suit, what this case is trying to tell us, in an ordinary suit, an answer to the petition is the suit, is the written statement of defense. You cannot bring evidence before you file the defense. Before you prepare that defense, you cannot prepare evidence. In fact, my lord, without that pleading, any preceding evidence would be anticipatory, would be speculatory, and the court cannot act upon it. I'm fortified by the decision of Phyllis, Wamaitha, Wahimia, and others. My lord, this decision is on page 29.